Hello and welcome to Shattered Lives. My name is Paul Healy. I'm crime correspondent with the Irish Daily Star and with the Irish Mirror. And I'm speaking to you today a little earlier in the week because I've just come back from the Conor McGregor appeal. This is his appeal of a decision by a jury that he assaulted Nikita Hand in the Beacon Hotel in December of 2018. And obviously people will be familiar with the facts of that case. And just a trigger warning to anyone who doesn't want to hear about sexual assault, obviously the facts of that matter where heard that Nikita Hand alleged that she was raped by Conor McGregor in the Beacon Hotel in 2018, and a jury ultimately sided with Miss Hand and found that Mr. McGregor was liable for her assault, and she was awarded almost €250,000 in damages in that very high-profile case in November of last year. Now, Conor McGregor is appealing that decision, and the first day of that appeal was heard today, and I was there in court. Quite tired now and absolutely sweating through this t-shirt. Maybe I smell a bit, but anyway, hopefully I don't smell too bad, that I can still get through this podcast with you and give you all of those details before I collapse. The Hugh Kennedy courtroom is where this case was heard. It's a very, very small, tight, compact space, and we were all being boiled alive in it. It's there in the Four Courts complex in central Dublin, and that is where Mr. McGregor is having this 2-day hearing. But really, we've heard the majority of the case today. I don't expect there to be too much more evidence tomorrow. There are 3 judges in this case in the Court of Appeal here in the High Court. And those judges are basically looking at matters of law that Mr. McGregor is bringing forth in his appeal. So just to explain to people, you can't just appeal on any grounds. You have to have grounds for appeal. And Conor McGregor in this case has 5 grounds of appeal, but a major one, really arguably one of the most significant pillars of his case, really sort of fell apart today in that he has withdrawn it from the case completely at the last minute. And we were expecting to hear from 2 witnesses that Mr. McGregor was pushing forward in this case. That is Samantha O'Reilly and Stephen Cummins. So we were expecting to see them today, and they were expected to be cross-examined on affidavits that they put forward in which they claimed to have witnessed an incident involving Nikita Hand and her previous partner on the night of, following the alleged rape on the night of the 9th of December 2018. The couple had sworn affidavits, and in it, Miss O'Reilly had alleged that she had seen from her bedroom window assault on Miss Hand by her then partner. She had claimed that she saw Nikita's then partner pushing her, moving his arms and hips as though he was punching and kicking her, and her partner claimed he was woken up by screams and shouts coming from Miss Hand's house, but that he didn't actually see what had happened. But those claims have been dramatically withdrawn by Conor McGregor's side today. And really, I suppose, we were not expecting that development. We were expecting to hear from those witnesses. And Nikita Hand herself was in the courtroom today, namely because our understanding was that she was going to take the witness stand in this appeal hearing because she was to be cross-examined, I suppose, on those claims by this couple, which she obviously completely refuted. And she said in her own sworn affidavit that the claims being made by Miss O'Reilly and Mr. Cummins were lies. The point being made by her side today, by Mr. Boland, Senior Counsel, and by Mr. John Gordon, Senior Counsel, was that Mr. McGregor's side were now effectively conceding that point, that these claims by this couple were lies because they were being withdrawn. We didn't get all of the detail as to why Conor McGregor's side are withdrawing those claims, but they also had another strain of evidence that they were going to bring forward from a former state pathologist from Northern Ireland. And his evidence was going to be used to, in effect, corroborate the claims being made by this couple. But because they were not advancing these particular claims, they were now withdrawing the evidence of that particular professor as well. So those are 2 major parts of the case that have now been dramatically withdrawn. And so Mr. Gordon, representing Nikita Hand, said that an apology should be forthcoming for his client for, I suppose, the ordeal that she's been put through to date. The fact that those affidavits were made public in court and that they were reported in the media, and that Ms. Hand had to endure those claims being made by this couple, which have now been withdrawn and no longer will be considered by the judges in this case. That apology has not been forthcoming yet, although the case is not yet over. Conor McGregor wasn't present in court today. He didn't need to be, wasn't required to be present in court. But his own counsel, Remy Farrell, senior counsel, was in court, as well as a Mr. Mulholland, both representing Conor McGregor in this case. And they were still advancing four other legal arguments in this case as to why they believe that Mr. McGregor is entitled to a retrial in this case. So Mr. McGregor is also arguing about, this is technical and quite legal, jargony, and so I'm not going to go into too much detail, mainly because it's difficult enough to understand, but it is there in my reporting and in the reporting by others, which you can go and read. But he was arguing about the admissibility. Remy Farrell, senior counsel, was arguing about the admissibility of his client's no-comment answers to Gardaí in 2018. So people may remember that Conor McGregor was the subject first of a criminal investigation. Obviously, the DPP decided that there would be no charges, but Gardaí were investigating the alleged rape on Nikita Hand, and they arrested and interviewed Conor McGregor in 2018 into 2019. And in an interview with Gardaí in Dundrum Garda Station, Conor McGregor issued his right of silence and gave no comment answers. 150 questions were asked and he answered no comment. And this was something that came up in cross-examination in the civil trial. And effectively, Mr. Farrell was arguing about how that was brought up, how it was dealt with then by the trial judge, and was arguing for a mistrial, as well, arguing for a new trial as a result of the way that issue was handled in the original case. And I'll come back to that. There was also an argument about the issue paper. So the jury in the civil trial were given an issue paper in which they had to consider whether or not Conor McGregor was liable for the assault of Miss Hand or not. And it was agreed by both parties and the judge that the wording on the issue paper was assault. It actually came up by Nikita Hand's counsel, Mr. Boland, that this issue was effectively agreed by both counsels in advance, and the wording was sexual assault, but that the judge determined the use of the word assault. But Mr. Farrell, on behalf of Conor McGregor, is arguing effectively that this issue paper issue was not clear, and that the jury may not have realised what they were deciding upon. Obviously, in rebuttal to that, Miss Hand's side of things are saying that the jury knew full well what they were deciding upon. But the main issue of the case, the thrust of the morning was about this particular claim made by this couple, which is now being totally and completely withdrawn by Conor McGregor. And in that, Mr. Mark Mulholland, KC, arguing for Conor McGregor, said that those grounds were unsustainable. And as a result of that, they would not be advancing those particular arguments. Now, in response to that, John Gordon, senior counsel, said that his client has been put through the ringer yet again. She answered it in her affidavit that this was all lies, and this has now been conceded, he says. He said that Mr. McGregor's side are coming in now thinking they can waltz in here and that they can walk away from this. Mr. Mulholland argued that there was no corroboration from Miss O'Reilly's evidence with that of Professor Crane, and that is why they weren't advancing the arguments of Professor Crane. And they said that therefore those arguments were not sustainable. He said it was the holistic view for both to be run in tandem, and with one not being run, the strength of the other was not sufficient. So they could not advance the arguments of Professor Crane without advancing those of the couple, and they were saying that there were reasons why they were not advancing those at this point. Now, Miss Justice Isabel Kennedy, who is the main judge in this case of the three judges who are presiding over this, said that it was unsatisfactory that this was now being withdrawn so late in the day. And she said that it was at the very last minute that this application was being made. So the judges got up and they actually went to consider this, and they came back in and they said, look, obviously, if counsel is not going to advance this argument, then that's the end of that. So Mr. Farrell then went on to speak about the other grounds for appeal that Conor McGregor has, and he spoke at length really about this no comment issue. So as I mentioned to you, there were 150 no comment answers, and basically he was arguing that John Gordon brought this up in cross-examination with Conor McGregor, and that a response that Conor McGregor gave to a particular question that he asked was used as a hook, as he put it, to say that Mr. McGregor was telling the jury that he wanted to tell the Gardaí everything. But he said that in actual fact, he was speaking about what he was saying to his solicitor at the time and not Gardaí. He said there is a remarkable conflation with what Mr. McGregor said and what was said to him in cross-examination. So Mr. Farrell submitted that there was an attempt made by Miss Hand's counsel to, quote, lead the evidence, and that this was an issue of contention during the trial, and that Miss Hand's side simply decided to take a punt on it. He argued, Mr. Farrell, that is, that there was a persistent attempt by Miss Hand's counsel to paraphrase the answer that was given by Conor McGregor during cross-examination, and he was submitting that this is simply not permissible. He said it was notable that the trial judge, Mr. Justice Alexander Owens, didn't deal with this issue, and that he was patently incorrect in terms of the conclusions that he drew and then stated to the jury later in his charge to them. Mr. Farrell said it is simply wrong, and in my submission manifestly wrong, with the manner in which the trial judge dealt with the issue in his charge to the jury. He further alleged that Miss Hand's counsel made an attempt to draw an inference from his client's no-comment answers, that there was, and that this inference was that there's no smoke without fire by giving no-comment answers to Gardaí. This came again in raising the issue about Mr. McGregor's right to silence, and that that there would be a larger issue here if there was an inference that a person was not allowed, that a jury was made to believe that a person is not allowed to give no-comment answers or say nothing during interview. He said that it was also clear that the trial judge, Mr. Justice Alexander Owens, took a view on this, whether intentional or not, to invite the jury to start drawing inferences over Conor's multiple no-comment answers to Gardaí. And he stated that Judge Owens identified the purpose of the cross-examination to the jury, but it was never followed through, and so the jury was left with what he said was a bizarre proposition. He said the question was never asked, and the jury was therefore invited to decide whether they thought Conor McGregor misled them or that he left them under a false impression. He said the reason the judge is scrambling for some other justification for the admission of this evidence is the witness had not been cross-examined for the admission of this evidence. And Mr. Farrell further stated that the jury were invited to draw an inference so that people cannot be allowed to sit in interviews and say nothing. So, as I say, that they may have believed that that there's something up about a person giving no comment answers in an interview. He also told the court that the evidence of the no comments was brought into the case without warning, and it was not pursued for what he said were the appropriate purposes. He therefore argued that in those circumstances, a retrial for his client is warranted. Now, the issue in relation to the issue paper and what was said on it, assault or sexual assault, Miss Justice Kennedy actually said to Mr. Farrell today that she actually asked the rhetorical question, was it not absolutely clear that Judge Owens made it quite clear in the trial that the assault in this incident was committed by rape? Now, Ray Boland, arguing for Miss Hand, he later said, as it happened, the draft prepared by Mr. Gordon said sexual assault. The draft prepared by the judge said assault. However, he said this was brought up with Mr. Farrell at the time, and they had agreed on the wording of sexual assault. He said, I say that that's the first defendant basically agreeing with the issue paper from which they are now criticising McGregor's side. Assault is a broad umbrella, he said. It covers sexual assaults. What we're dealing with was assault by rape. There was no ambiguity whatsoever, he said. And he also said that it would be an insult to the jury to say that they didn't know what the issue in this case was about. On the no comment issue, so Mr. Boland, he said there had been a breakdown in communications during the trial, so he conceded that. But he said that if this was such a serious issue at the time, that Mr. Farrell could have made arguments at the time about discharging the jury, but he didn't. He could at that stage have made an application to discharge the jury, which wasn't made, he told the court. He also stated that the no comment answers by Conor McGregor were not hugely probative, other than Mr. McGregor was putting himself forward during the trial as someone who wanted to cooperate fully with Gardaí and that he didn't. He said that's the reason why it was put, and he told the court that it became clear at one point during the cross-examination that he was asking Mr. McGregor about his cooperation with Gardaí and not his solicitors. He went on to say that Mr. McGregor was putting himself forward to the jury as someone who wanted to cooperate as much as possible. That's the picture he was attempting to put forward before the jury, he said. So Mr. Boland for Ms. Hand said, look, no injustice was done here in this case, and Judge Owens was correct to allow this evidence of these no comment answers.